Chief Judge DiFiore is recused in this particular case. People versus Martesha Davidson. Mr. Lalonde, welcome.
Thank you, Judge. Good afternoon. Robert Lalonde for Martesha Davidson. This case is about the power of the special prosecutor that was
Would you like any rebuttal times?
No, thank you. Yep. Special prosecutor, which was created by the Protection of People with Special Needs Act, yes.
Did defense counsel below attack the constitutionality of the statute?
Well, Your Honor, I think he did. He filed a letter motion to dismiss, and in that letter motion, he did cite 3 points. And point one was that it was only the locally elected DA who's got the power under the New York Constitution to prosecute. And then he went on to make 2 other points. One was there's no probable cause to arrest. And then the third point was challenging the power of the special prosecutor to appear in the local court. And it was
Yeah,
that.
I looked at that letter, that probable cause in the same paragraph. It's sort of the closing statement after that first sentence that you are correct, where he says, under the Constitution, only the DA has the authority to prosecute. I agree with you, that is what that says. The rest of the paragraph doesn't seem to really go any further than that. Can you just say it's unconstitutional, or the DA is the only one who under the Constitution has authority? Is that enough for,
I think it is.
for town court to know the nature of this constitutional argument?
I think it is. I mean, he's clearly saying it's only the local DA who, under the New York State Constitution, I mean, that
Is that a
phrase-
separation of powers argument? Or is that some other argument? What's the nature of the constitutional argument?
Well, that's not clear.
At the hearing on this, did they ever talk about the Constitution and the nature of this constitutional argument and the theory?
What I'm arguing in terms of preservation is that sentence. That's what's there. You know, there was not.
I'm a little confused on that because it seems, I think you can argue that the issue was preserved, but it seems like this issue was waived. In the brief, I got appellate brief, page 4. The appellant is not arguing that Article 20 of the executive law is unconstitutional. Then it goes on to say only the foregoing analysis. Can you tell us what it seems to me like you've waived this issue?
Sure. Well, Your Honor.
Expressly waived this issue.
At the intermediate appellate court, I did raise a direct constitutional argument. I said, hey, this statute is not constitutional. I did not make that argument here.
So my reading of the appellate brief is correct. It is expressly waived.
Well,
you see, let me just finish the thought.
Sorry.
It creates a problem because the AG is only here is in an amicus brief, and if you've expressly waived it, then I don't see how they can argue on the constitutionality issue also.
Your Honor, I disagree that I have waived it, and it was not my intent to waive the constitutional issue. I raised it in the way I did because I thought that would probably be, that would have the most chance of success.
We'll have to decide it, but I don't want to make it not let you make your argument, but I'm just saying I just wanted to point it out.
If the constitutionality is doubtful, as if we ascribe some arguable merit to the AG's argument, would that be relevant to our analysis of the statutory interpretation?
Yes, I think it would. What I am saying is that the special prosecutor is only authorized to appear before grand jury or in county court, that's the plain text of the statute, and that to interpret the statute otherwise, to allow them to prosecute as they have in this particular case,
create constitutional
creates a constitutional problem. That's the constitutional argument I am making here.
Well, yes, even with what you acknowledge is the statement in the brief that you're not challenging the constitutionality, it is true that other than the reference to the statute, you are talking about the constitutional powers
Exactly.
that are at play in this case.
That is exactly the argument I'm making. To interpret the statute in the way I am asking the court to interpret the statute does not render the statute unconstitutional.
Isn't it inconsistent, though, with the whole purpose of the statute? I mean, this statute created 26024, right? It was created at the same time, and specifically to prosecute the crimes that the special prosecutor was appointed to do, and that was the whole purpose of the statute. So it seems inconsistent if we're going to say that a special prosecutor only could prosecute felonies but not misdemeanors, and yet we create, I guess it was an A misdemeanor, 260-24. It doesn't make any sense. The statutory history doesn't support it. That inconsistency seems difficult to reconcile.
Judge, I might not be understanding the question, but
The special prosecutor, your argument is can only prosecute felonies, not misdemeanors. Right. We're on the same page on that, right?
Judge, we are not on the same page on that.
Okay, go
I
ahead.
believe the special prosecutor can prosecute misdemeanor cases.
Okay. All right.
What I am saying is that in order to do that, to prosecute any case, they must present the case to a grand jury.
I see.
And that the
Okay.
issue or the problem, you've got the special prosecutor, governor appointed, in no way elected, and they can, at least in this case, unilaterally make the decision to come in and file charges, and that's without any sort of input from.
Would they need the consent of the DA, though?
I'm not opposed to this court interpreting the statute that way. That's not what I'm asking the court to do.
Was there consent here? Or do we know? Or-
There's no, I mean, I guess I have some personal beliefs based on talking to the prior attorneys, but I don't think there's a record regarding that. And I'm not opposed to this court, laying out some sort of framework where, consultation, consent, permission from the local DA.
Let's
Well-
go down that rabbit hole for a moment, and I certainly will be asking the other lawyers, what's the nature of this consent? Does it mean, yes, go right ahead and prosecute, or does it mean I have to supervise, the DA has to be aware of every strategic choice and approve every strategic choice? What does that mean, consent?
Well, I think it means, I think it does mean approval,
To pursue a prosecution?
yes.
But what if,
And
what
it-
if the DA doesn't respond, what if the special prosecutor requests and the DA doesn't respond? How do we interpret that? Is that consent, or is that, just ignoring it?
Well, I think there has to at least be some, at the outset, there's got to be some kind of request or contact from, the one prosecutor to the other.
Doesn't the statute say that the special prosecutor must consult with the DA or give notice to the DA?
It certainly does. Section B, if they're applying for warrants, they have to give notice. Section C, if they're appearing in front of the, grand jury, they have to consult. I guess I didn't come prepared to suggest a framework for what that really means. What I'm concerned about is what happened in this case, which is, I think there was a New York State trooper who went out and investigated this case and met with the Tompkins County District Attorney, and the decision was made not to file charges. And then it was the Justice Center's investigator who, reinvestigated, and then it was the special prosecutor who went ahead and filed charges.
Not exactly what the statute's designed to do, because people weren't prosecuting these cases.
Well, I don't disagree that that's what the statute's designed to do. What I am saying is that if, under those circumstances, the special prosecutor wants to bring a case, they have to present it to a grand jury, because at least that gives a defendant, some sort of protection from this non-elected, governor-appointed only prosecutor. That at least under, that kind of situation, there's grand jury protection.
So the legislative history about concurrent authority then doesn't really matter under your grand jury argument, right?
Well, I think that's right. I mean, if they truly are allowed to have concurrent authority, I think that begins to raise the constitutional concerns.
You waive that. Yeah. Okay.
Okay. Thank you.
Thank you. Ms. Underwood, good afternoon.
The New York Constitution recognizes only two offices with prosecutorial power, the county DAs and the Attorney General, both elected officers. This is the first time the legislature has ever purported to create a new special purpose prosecutor who is not accountable to either the district attorney or the Attorney General. If this court were to endorse the practice, there may be many more.
The statute requires consultation or consent. Does that address the concern?
No, it doesn't require consent unless you read that into it. I think the plainest we would suggest that you could read that into the statute, but the language is consultation and
what
not
would that mean under the statute?
Pardon me?
To the extent that you say that the statute is therefore unconstitutional, what is the statute anticipating as consultation?
Well,
I assume you mean less than approval.
yes. I understand consultation to be a different word from consent and to be deliberately chosen that way. Were you to construe it to mean the same thing, I think that would take care of the constitutional.
That'd be tough, because people consult with me all the time and disagree with me right after that, so it's
Well,
pretty
that's-
common.
But maybe I can follow up on the question I was asking before. So what would be the scope of consent? Is it supervision by the DA? Is it that the DA must approve strategic choices? What does consent mean
Well,
to survive the constitutional
yes,
question?
I'd like to take that question in two parts if I could, because as to misdemeanors, we have this common law tradition of prosecution by non-prosecutors, by police officers, by complainants, by victims in some circumstances. And even as to that, this court has said there needs to be approval by the district attorney and ultimate responsibility, but it seems for that it might be sufficient for the district attorney to approve the general practice as distinguished from close monitoring of every case.
Is that so, Donald?
Yes.
Are you saying that the statute's poorly drafted?
Well, I'm saying it wasn't drafted to deal with the problem I'm talking about here. And one of the reasons we're here, I think, is that perhaps is to bring the constitutional issue to this court's attention and to try to find a solution to it. Because there is no doubt that the Justice Center is a useful, important way of bringing resources and expertise and so forth to bear on a problem. It could easily have been, altered slightly to deal with the constitutional problem. And if this court approves this arrangement, there is no distinction analytically between this and a special, unelected, unaccountable prosecutor for any crime du jour.
Isn't it a bit of a stretch to say the legislature left to common law misdemeanor prosecutions in a statute such as this?
I don't think the legislature intended to do that. I'm suggesting two different analytical ways to approve the prosecution, even though not alluded to directly in the statute.
So in a way, I know I'm putting words in your mouth, you're agreeing with Mr. Lalonde that there is no statutory provision allowing the Justice Center to bring misdemeanors in local village courts or town courts.
Well, our argument overlaps his to a considerable degree. It's not identical. That is to say, our position is that under the statute, the statutory construct, which doesn't distinguish between misdemeanors and felonies, seems unconstitutional in the sense that it creates a prosecutor who is not accountable in any way, either to the district attorneys or to the Attorney General.
And requiring that misdemeanors be brought to the grand jury doesn't solve your problem.
Correct. I don't think the grand jury is a substitute for the Attorney General or the district attorneys. But I do think that this prosecution, which is a misdemeanor prosecution, could stand if it were understood to be, if the prosecutor were understood to be authorized not by the statute alone, but by the common law authority of law enforcement officers to bring misdemeanor prosecutions. Now, that doesn't solve the situation for felony prosecutions, but this is not a felony prosecution.
And so let's talk about the felony. So that would be resolved either saying it's unconstitutional or that we somehow read into the statute consent.
That's correct.
And now we're back to my question of consent. You've sort of
And what
answered
would
it
the-
on the common law side.
Right. And what would the consent mean? Well, I think the consent would have to be that the district attorney is ultimately responsible for the decisions that are made. It is not the case that that means the district attorney personally has to be intimately involved in every strategic decision. What it means is, for example, in this case, if you imagine this was a felony, the record can be read, I believe the defendant reads it, to say that the district attorney didn't want there to be a prosecution.
Or it can be read that he
Or-
really didn't care.
That's
But
correct.
here's
But
my-
those are two different.
Here's my concern, and I raised it before. There were a series of horrific reports that led to this legislation, right? We can all agree those were terrible events. Legislature felt nobody was prosecuting them. In this case, the DA wasn't going to prosecute. You're asking us to declare this statute, at least in your first point, unconstitutional. Is there any plan by the Attorney General, if we agree with you, to take over in some way or to coordinate some response to address that issue?
Is there a plan? Well, we have proposed a plan. If you don't read into the statute.
But let's say we go with your point one, it's unconstitutional. Do you have any plan then to take over or to somehow coordinate?
Our recommendation would be that the Justice Center get consent from the.
But let's say we don't go, let's say we
No, but
believe
even
your
if you don't,
first argument.
even if
It's
you don't go with that,
unconstitutional.
even if you don't go with that, there's nothing to stop.
So the answer is no, right? I mean, if we declare the statute unconstitutional, there is nothing then. So we're back to square one in terms of this population.
I think what we need is a minor adjustment to the statutory scheme. It can be accomplished in one of several different ways. It can be accomplished by reading a requirement into the statute. It can be accomplished by your saying that that is required and
Your
the
first point is the New York Constitution does not permit the legislature to create a special prosecutor for a class of cases independent of a county district attorney or the attorney general. That doesn't say read something into the statute to me.
Well, what we've said in points 2 and 3 is here is how you can solve the problem.
Alternative. But if the way I read it, if
They're
we
not
find it
alternatives.
And say, based on our precedent of trying to read this particular statute, or any statute, in a way that would make it constitutional, that this is your suggestion of how this court could do so based on the language and the text.
That is correct. We have no interest in dissolving the operation of the Justice Center.
I believe that. But if we decline to read the language in, then your position is it's unconstitutional.
My position then would be that the legislature should amend the statute to
Okay.
put the requirement in that of district attorney consent. And the Justice Center's final point in their brief in response to our amicus brief says that that's not so hard to, it's not what they want, but that could be accomplished. I don't want to speak for
I
them.
thought they conceded that this is what they do in practice.
Well, what they concede is that they consult, they notify. I don't believe they
The
have
consent.
said that they get consent.
Can I ask, just go back to, I think, something Judge Garcia mentioned before. Let's say the DA either, as I think he suggested, is not interested, so takes no position on it, or, as perhaps counsel was suggesting before, has done an investigation and decided there's not probable cause. I wish not to deploy my resources from my office to this particular prosecution. Can the Justice Center then go ahead? Is that consent?
Well, it depends on, I mean, we discussed several possibilities. If the district attorney had decided that he doesn't want to deploy or she doesn't want to deploy her resources and consents to the special prosecutor proceeding, that would be fine. If, on the other hand, she has concluded that this defendant, that there is no evidence and this defendant shouldn't be prosecuted, that isn't consent. And I would think that that a remand to determine that on the facts of this case might be an appropriate way of resolving this case, depending.
So under your approach, a DA either has to on their own decide that they are going to pursue this prosecution because they find probable cause, or decide, I think there's probable cause, I'm willing to consent to the special prosecutor to do it. But if they've actually done an investigation and decided there's no probable cause, they cannot choose to either sit back and take no position on it or delegate and say, if you want to prosecute, that's your business, but I am not going to spend the resources because I don't think there's probable cause.
Well, when it's a resource question, they would presumably consent. When it's a judgment about the validity of the prosecution, I think that's not consent, and that then should bar the special prosecutor
And
from moving
I know
forward.
your light has gone off,
That's-
but if I
I'm
may.
happy to-
So if they're just overburdened, because I think in part the legislation, the history is suggesting it's the demands on the DA office, the lack of perhaps resources to do all
Or
these cases,
expertise, or whatever,
yes.
yeah.
And so they haven't made a decision either way. Under your approach, they can consent to allow someone else to make this decision. Why isn't that a delegation of a core, essential duty and obligation of the district attorney?
I think they ultimately have responsibility under that construct, and that when you delegate to somebody else under the cases of this court, you ultimately have the authority to overrule them, but you can still appoint somebody that you think is wise and expert and who will, in the ordinary course, be making these decisions and consent to that arrangement.
So you see it as an appointment when you say this consent?
Well,
I'm
they're
allowing
very-
you to do this part of what I would ordinarily do under the circumstances, and you must come back to me so that I can decide whether or not.
Well, you must make some sort of report to me. Some of these are in small places. There are various ways that a relationship between the district attorney and the special prosecutor could be
The
manifest.
special prosecutor thinks, I think there's probable cause here, we need to move forward, and the DA says, no, I don't agree. The
Well,
DA has the ultimate responsibility,
I think the DA
correct?
has the ultimate responsibility, that's right. It seems unlikely on the evidence of how this particular statute came into being, but one could imagine other special prosecutor statutes, more high visibility matters where there would be a profound difference of opinion, and somebody has to have the authority. And that's really why we're
How does
here.
that work, counsel, when there's overlapping authority, or, for example, Martin Act prosecutions where the DA has the
There's
authority
concurrent
to do it,
assurance.
and it's concurrent jurisdiction? How does that work?
Well,
Does the DA have to get the
no,
AG's consent,
when
or-
there's concurrent jurisdiction, either prosecutor can move forward and doesn't have to consult the other, and there are sometimes, rarely, but sometimes conflicts about this. But the Constitution contemplated 2 prosecutors. It didn't contemplate 3 or 4 or 5 or 10. And all those problems of concurrent jurisdiction are proliferated when there are more prosecutors. And I think that's the difference, that there's a constitutional choice that's been made here. If I could just say one thing, and that's that the Attorney General here is here to protect the constitutional limitation on multiplying prosecutors and to try to save this statute, this prosecution, and future prosecutions by invoking the authority of the constitutional prosecutors, the district attorneys, and/or the Attorney General.
Thank you, Ms. Underwood. Ms. Forshaw, good afternoon.
Good afternoon. Before I begin, I do believe that there are some preservation issues in this case and some issues with respect to whether or not these constitutional claims are preserved. Certainly, there was a sentence in the defendant's motion in the trial court claiming that only county DAs have the authority to prosecute. That's certainly not the argument that the Attorney General is making. The Attorney General is making the argument that county DAs and the Attorney General have the authority to prosecute. And in fact, the Attorney General is not a constitutionally created prosecutor. This court has said on numerous occasions that the Attorney General only has the authority to prosecute that's given by the legislature. So I think this case presents a really simple question, and that
He is an elected official.
He is an elected official, absolutely. But the question is the legislature, which has been given by this court exclusive authority to determine who should prosecute in a particular case?
Or is that just a question of dividing up the responsibilities rather than choosing what entities among any can actually prosecute?
Well, this court has said that the legislature can choose to give prosecutorial authority to the governor, the attorney general, or DAs. And that was
And they're all
People versus
elected.
Johnson.
They're all elected officials.
They're all elected officials, right? And it was an elected official, the governor, that was given the authority to appoint the special
Well, do you agree,
prosecutor in
Ms.
this
Underwood,
case.
that you need consent, or are you arguing that you only need to consult?
I don't believe that the statute can be read to require consent.
Okay, and that leads to what I gleaned from the Attorney General's brief. If the legislature tomorrow said, we think guns are a problem, we're going to appoint a special office, special prosecutor on guns, and not only that, we think drugs are a problem, and so we're going to appoint a special office and a special prosecutor on that, and we also think domestic violence is a problem, so we're going to appoint a special prosecutor and set up a special office on that. Are all those okay? And and assuming for a minute that we have those, does the DA have any say in who's going to get prosecuted and who's not going to get prosecuted in their respective counties?
I believe that under this court's case law and consistent with the Constitution, the legislature could do that. I believe that what the check is on the legislature, of course, is the political process. The legislature is unlikely to do something like that, which may be presumably wildly unpopular with the citizens
Well, that's
who
somebody
elect
else's problem.
them.
I'm
Right.
just thinking legally, because they make the argument that you're really cutting into the elected officials' authority. And I can see consult, but if this new prosecutor says to the district attorney in, let's say, Erie County, I don't care what you do, I want a grand jury, I'm going after these people, and by the way, you better set aside some office space for me because I'm bringing 30 prosecutors, 40 investigators, and we're going after them. Can you do that?
Well, I think the legislature in this case prevented that from happening because there's specific language in the statute that indicates that the Justice Center special prosecutor shall not interfere with the ability of district attorneys to investigate and prosecute
Oh, no, make me the prosecutor up in Erie County. I'm not going to interfere with the DA at all. In fact, he can go on vacation. Let me know when he gets back because I need his office and I need the grand jury room and I need his investigators. I'm not interfering at all. I'm just going to go after people.
No, but I think that would be interfering with the choice of the district attorney in that
Do
case.
what?
To decide on how certain cases will be
So
prosecuted.
do you need his consent before you go ahead with those cases?
No, I think you need
So
consultation.
even though you say he has an interest in getting that done, you can do it without his consent.
We can, absolutely. I think it would be
You're
foolish.
completely independent.
I think we are independent only to the extent that there are a number of provisions that require the Justice Center to give notice to district attorneys and to consult with district
So
attorneys.
okay, so let's parse that out. What's difference in your mind under the statute between notice and consult? Because the independence you just described sounds to me like it's only notice. So what has ratcheted up, what is consultation
Right.
as you read the statute?
Well, with respect to notice, notice is, here is this case that we believe alleges criminal conduct.
Can I stop you there?
Yes.
Say, here's this investigation.
We could say, here's this investigation, the way the statute is written, when the
We're
Justice...
investigating the 30 nursing homes in Wayne County. Notice, done.
Right.
Right? That's all you need. And now you're in and out you go.
Right. Well, no, and then before appearing in a grand jury or in the county court, we have to consult with the district attorney
That's 'cause
with
you-
respect to scheduling.
Okay,
Don't
so
you
what does
need
that
him-
mean? What's the
Don't,
consultation?
excuse me, Judge, don't you need him to impanel it, or do you have the power to impanel it?
We don't have the power, and that's why the consultation is important. It's limited to those kinds of scheduling matters
Well,
for which...
Is it scheduling or is it consent? I mean, if the DA says, I'm not letting you in my grand jury, can you get in?
Probably not.
So you really need his consent.
Well, no, the statute talks about consultation. I think that what you're talking about is an objection, not consent, and I think that's
Oh,
very different.
You can call it an objection, but if he says you're not coming into my grand jury, you're not coming in, you're going to sue him and say under our statute, all we have to do is ask him, it's an unreasonable denial, and we're entitled to his grand jury.
Our policy is to consult and to collaborate
No,
and
I
to
think you're
seek
misunderstanding.
cooperation.
I understand. You people are cloaked in gold. You are pure as the driven snow. You're only going to do what's right. Someone else might disagree. And if there's a disagreement, my question is not, of course we'll never do that. If you're going to do it, I mean, do you need the DA to say, to consent to your use of his grand jury? And you're saying no. And so if he says, well, you're not using it, then isn't there a conflict here?
We haven't faced that situation,
No.
so I don't really know the answer to that. Typically, we obtain the acquiescence. We don't obtain affirmative consent or affirmative approval. And I think the legislature was very clear not to read those requirements into the statute.
What if they did object? You said objection isn't the same as consent. What if the DA said, I don't want you to do this? What if that happened after the grand jury was impaneled?
I think at that point it would probably be too late, because at that point the grand jury has acted.
Well, no, what if the grand jury hasn't acted? It's been impaneled, so you have what you need from the DA to move forward, and then the DA says, you know what, no, I don't think so. Then what happens? So there's an outright objection. The grand jury hasn't met, nothing has commenced, but there you have it. Then what do you do?
Probably at that point the Justice Center would walk away and hope that the DA does the right
Oh,
thing.
you don't think that you would have to walk away? That
I
would
don't
be a
think we would
choice.
have to. I think that what we would do is we would try to persuade the district attorney to review the case and to permit us or
Doesn't that
to...
imply consent?
I don't think so. I think that, there's no obligation for affirmative consent.
What are you trying to persuade him to do?
We would be trying to persuade him to either present the case himself to the grand jury or to allow the Justice Center.
Doesn't that sound like consent?
Not at all.
Okay.
Not at all.
Can I ask you the flip side? Suppose the district attorney of some county wants you. Do you have to come?
We don't have to come. We typically do come, and that's been a rarer situation. I mean, what we do often is we provide assistance. Sometimes we jointly prosecute cases. Sometimes we prosecute by ourselves, and sometimes we hand the investigation over to the district attorney so that the district attorney can pursue it. I mean, district attorneys know their counties
Yes,
more than we
If
do.
you're pursuing, I just want to clarify, your position is that, and the DA has felt comfortable with you pursuing it, is your position that you do not have to seek further consultation with respect to strategic choices? You don't have to report to the DA? Your position is, once the DA approves you to pursue a prosecution, then you're independent, you run that prosecution the way you believe it should be run? Is that your position, the way the
Absolutely.
statute should be read?
Absolutely. I mean, it would be foolish of us not to talk to the district attorney because, as I said, the district attorney knows their county, knows jurors in their county. So it would be foolish as a prosecutor not to engage in conversations, and we certainly do.
Could I go back to something you said earlier about which elected officials have prosecutorial authority? And you mentioned the governor. When has the governor had prosecutorial authority?
The governor doesn't have direct prosecutorial authority, but what this court has said is the legislature can delegate law enforcement functions to the governor, the attorney general, or the district attorney. The legislature has not directly given prosecutorial authority to the governor, but there are a number of statutes in which the governor can appoint or create or activate legislative authority, prosecutorial authority, including activating the attorney general to have prosecutorial.
Back to this case, in Tompkins County here, the DA apparently decided that there was no reason to prosecute this case.
Right.
You apparently decided there was. How does that get resolved? Obviously, if you don't need his consent or her consent, you're fine. But if you do, then you're out of luck, right?
As Mr. Lalonde indicated, after an initial state police investigation, the district attorney decided not to bring criminal charges. There was an additional investigation, and certainly just because the state police investigate and might not find enough evidence for the DA to feel comfortable prosecuting doesn't preclude the Justice Center from conducting additional investigation. And in fact, we would be obligated to, because even if we're not pursuing a case criminally, we also conduct an administrative investigation so that we can take action against caregivers who are accused of abusing or neglecting vulnerable people.
You know, one of the things we haven't gotten to is the core of the home rule argument that the Attorney General made. And it seems to be, let's say it's a home rule argument, that this is a general law, so it applies to every county in the state. So as we move down the list on the home rule question, then we want to turn to the constitutional challenge that asserts that by the AG that the state legislature is barred from transferring essential functions of elected constitutional officers to officers that are selected by appointment. That's the way I understand that. I'm quoting directly from their argument. But that's not really what we're talking about here. What we're talking about are prescribing the powers of the district attorney. And I want you to speak to that because it seems that the Constitution doesn't set out, or in one way or the other, the duties of the district attorney and doesn't describe their essential functions. And it seems that the legislature's been left with that task. And as according from county law, all prosecutions for crimes or offenses cognizable of courts which either should be elected or appointed, that is a legislative function to designate what those particular laws and functions are. And that includes prescribing the essential functions of the district attorney.
Absolutely. There's nothing in the Constitution that explains exactly what the district attorney's powers are. That choice of what those powers are has been left to the legislature, and the legislature passed a statute, the County Law 700, that sets forth what the duties are of the district attorney. And just as the legislature can grant powers to the district attorney, it can also take those powers away. That has to be the only construction that can be given to the fact that, as this court has recognized, the legislature is the exclusive body that has the ability to determine who
Well, the
should
biggest
prosecute.
example I think of that is a superseder power of the governor under Executive Law 63, whatever. Two, okay. And then other examples are County Law 701.
Correct.
It seems that in those instances that the DA does not really have exclusive authority to prosecute crimes within the state. Clearly, they have authority to do so. So the question then becomes, is the grant of concurrent jurisdiction valid?
Absolutely. There are a number of situations in which different prosecutors have concurrent jurisdiction. One example that was mentioned was the Martin Act. Under the Martin Act, district attorneys can bring security fraud cases, so can the Attorney General.
But they're both elected officials.
That's correct. But
Why isn't that?
But the Attorney General, as an elected official, the only reason the Attorney General has the authority to prosecute in certain instances is because either the governor activated that power or the legislature specifically gave him that power.
But isn't the constitutional argument not solely about the nature of the duties and obligations, but also how the person is selected, who they're accountable to? And in these examples, the AG and the DA, they're accountable to the electorate. Right? JC here, the special prosecutors are accountable to the governor only.
The governor, who is an elected official. And so I do think it's exactly analogous. And I think that these types of distinctions are really more form over substance. And I think substantively, it's not unique for...
No. What is analogous is the ADAs, right, to the DA. DAs elected, ADAs are not.
Mm-hmm.
That's the analogy, but not
Right.
the special prosecutor to the governor. I don't think that's making your argument.
Yeah, I do think that it is, with all due respect, I do think that
But
it
the
is
essential
analogous.
nature of the governor's job is not to prosecute.
And the essential nature of the Attorney General's job is also not to prosecute. The Attorney General has been
But the
given
DA for certain it
limited
is,
authority.
and the special prosecutors are defined as DAs, right?
The special prosecutor is defined as a district attorney,
The point
absolutely.
of that job is to prosecute, right? Investigate and prosecute.
That's correct.
Not these other responsibilities and so forth of the governor.
That's correct. That's correct. But that person is only activated by having the governor actually appoint them. just like the governor has the authority to activate the Attorney General's authority by making a request pursuant to Executive Law 63.3 or 63.2. I would also like to point out, if I could just have 1 second, that in fact the record shows that the Justice Center did notify the district attorney in this case of our prosecution. In the record in the appendix at 15, that set forth.
But we don't
in-
know what, if any, response there was.
Exactly.
I'm sorry, what was the number?
In the appendix at page 15.
15, thank you.
The prosecutor notes in response to the defendant's motion that the DA was notified of our appearance.
Thank you, Ms. Forshaw.
Thank you.